Welcome, everyone. I'm Russ Feingold, President of the American Constitution Society, the country's foremost progressive legal network with more than 200 student and lawyer chapters across the nation. It is my pleasure to welcome you to today's Constitution Day event, Founding Failures, Indian Country's Sovereignty and Subordination. ACS is celebrating its 20th year of shaping legal debate, nurturing the next generation of lawyers, judges, and advocates, and ensuring that the law is a force to improve the lives of all people. If you don't already, we encourage you to follow us on social media, including on Twitter at ACS Law. You can also find us online at acslaw.org. And there you can join ACS and find more information about upcoming events and opportunities. We are focusing our work in this anniversary year on our Constitution's founding failures when it comes to race and equality in this country, and reckoning with our past to create a more just future. Constitution Day is no exception. September 17th is designated by act of Congress as Constitution Day and Citizenship Day, a day on which we as a nation commemorate the formation and signing on September 17, 1787 of the Constitution, and recognize all who by coming of age or by naturalization have become citizens. It is a day that we at ACS revisit our founding document with pride, lifting up its promise. But we cannot ignore the ways in which certain groups were and continue to be ignored or marginalized within its text and history, including Native Americans, whose treatment and status within our constitutional scheme is the focus of today's discussion. We cannot fully appreciate and understand the Constitution without better understanding the provisions that directly address tribal sovereignty and the harm that the United States government has committed against tribal nations and their people. We cannot fully understand and appreciate citizenship without acknowledging the fact that Native Americans were deprived of full birthright citizenship until the Indian Citizenship Act was signed into law in 1924, and full voting rights until the enactment of the Civil Rights Act of 1965. Indian law has too often been kept at the margins of the American legal narrative, despite important questions that implicate our entire system. ACS strongly opposes this kind of marginalization. I know our panel will get into many of these issues today, and I'm looking forward to learning more from such esteemed panelists. Before we dive in, one very brief housekeeping note. You can find the information on the CLE credit available for this panel in the chat box. If you're unable to view the chat box or need help, just email info@acslaw.org with the Constitution Day CLE in the subject line. I'd now like to turn it over to Ambassador Keith Harper, who will be moderating today's panel. Ambassador Harper is a member of our ACS Board of Directors and chair of the Native American practice at Jenner and Block. His areas of practice include government and regulatory litigation, Native American litigation, and counseling on international matters. Harper served in the Obama administration as U.S. Ambassador and permanent representative to the United Nations Human Rights Council in Geneva, Switzerland, and as a citizen of the Cherokee Nation, was the first ever member of a federally recognized Indian tribe to serve as a U.S. ambassador. Ambassador Harper, take it away.
Thank you, Russ. And let me just take this opportunity to say how much we've enjoyed working with you and watching your leadership and your tireless advocacy for ACS. And thanks for the introduction. And I just want a warm welcome to everybody as well for Founding Failures, Indian Country's Sovereignty and Subordination. We have a very distinguished panel that I would like to introduce, and then we'll dive right in. First, Elizabeth Reese is Assistant Professor of Law at Stanford Law School and is a nationally recognized expert on tribal law and federal Indian law. Previously, Professor Reese worked at the National Congress of American Indians and the NAACP Legal Defense Fund. In addition, we have Matthew Fletcher, who is the Foundation Professor of Law at Michigan State University College of Law and Director of the Indigenous Law and Policy Center. He sits as a tribal judge or justice on tribal courts all over the country. I've worked with him in his role as reporter for the American Law Institute's inaugural restatement of the Law of American Indians. Chase Iron Eyes is lead counsel for the Lakota People's Law Project. He is a co-founder of the Native news website, lastrealindians.com, and works extensively with Native Lives Matters movement. In 2016, he was the Democratic congressional nominee from North Dakota. And last but certainly not least, Addie Rolnick, who is the San Manuel Professor of Law at the University of Nevada, Las Vegas, William S. Boyd School of Law. He is the faculty director of the Indian Nations Gaming and Governance Program and the associate director of the program on race, gender, and policing. Sorry. So we thought we'd just one final housekeeping note before we turn it over to our panelists. If you'd like to ask a question at any time during our session, please type it into the Q&A box on the bottom of your screen. We will be taking questions after the initial discussion, and we'll try to address as many as possible. A discussion of the Constitution and American Indians could not be more timely. It seems nearly every year of late, there are massively important cases with huge implications for Indian country and Indian tribes that are litigated. Last term, the Supreme Court decided the Cooley case and determined that yes, tribes do have the inherent sovereign authority to perform Terry stops. This year, a couple of weeks ago, 4 petitions of certiorari were filed in the Brackeen case, including by the United States. Brackeen is a challenge by a group of individuals and the state of Texas to the constitutionality of the Indian Child Welfare Act, or ICWA. ICWA basically is a 40-year-old statute enacted to address the widespread and often unjustified removal of Indian children from their homes, up to 1/3 of tribal children. An en banc Fifth Circuit in an aggregated 325-page decision by narrow votes upheld most of ICWA, but struck down a few provisions. The case involves 5 separate constitutional issues, including what are the powers of Congress in Indian affairs? The Supreme Court has often called them plenary. Equal protection. In other words, how are Indians able to be treated differently under the law? The anti-commandeering doctrine. Does ICWA commandeer state officials in carrying out federal law? The non-delegation doctrine. What can Congress delegate to a sovereign Indian tribe? And finally, standing. Because it presently is being litigated and may find its way to the Supreme Court, I thought this would be a good place to start our conversation on the Constitution and American Indians. So with that, I'd ask Professor Fletcher, Matthew, if you would please provide some initial comments on this topic. Thank you.
Happy to do so, Ambassador. Thank you so much for the ACS to invite me, and it's a great honor to be able to participate in today's conversation. So my role here today is to talk a little bit about the Brackeen case, and this is one of those cases that is truly a once-in-a-generation type case. It is a direct challenge to the scope of Indian affairs powers from Congress, and also what is viable under the Constitution in terms of remedying the discrimination that occurs to this day against Indian people. So as Ambassador Harper mentioned, there are 5 key constitutional questions. But before I get into a short description of each of them, I want to highlight something about the Constitution that doesn't come up a lot in our conversations about the Constitution. We often talk about the founding fathers, the founders. We often talk about original public meaning, originalism. What we don't talk about is that the Constitution was debated and ratified at a time the United States was at war. One of the most important wars that the United States has ever entered into, but one that very few people know anything about. We don't even have a name for this war. Many Indian people call it Little Turtles War. It's often called by academics the Northwest War. But it's a war that started in about 1784, 1785 in the Ohio River Valley between a confederation of Indian tribes, primarily led by the Shawnee Nation, against the United States. The United States desperately wanted to have the Ohio River Valley, and that was the first thing they chose to go after the revolution was completed. In fact, before the revolution, frankly, was completed. They primarily were losing this war to Indians in 1787 and even in 1789 when all of the Constitution was finally ratified. And that's important to remember about this Constitution, that it is a wartime Constitution. And so I'll start with that. Let's talk about the Brackeen case. It is a challenge to the Indian Child Welfare Act, which was passed by Congress in 1978 in order to remedy the fact that around the country, 25 to 35% of all children who were of Native heritage had been removed from their Indian families. 85 to 90% of those children were placed with non-Indian families. This is all done primarily with an eye towards taking Indian children away from their reservation homes, away from their Indian families, and placing them for assimilation purposes in non-Indian families. This was going on as late as 1978. ICWA was designed, as we call it, to remedy that, to prevent it. So the broad national context of ICWA is that in 1978, there really was not much child welfare law on the books. Most states did not require in any child welfare proceeding due process for parents who had had their children removed from them by Child Protective Services or any kind of social services agencies run by the states. ICWA was the first national attempt to actually think about what a child welfare code would look like. And it happened to be Congress putting that together. So because of ICWA, most states have finally adopted rules requiring, many states have required rules, including the right to counsel, even the right to be notified of an emergency removal hearing, to be able to see the evidence against the parents, to look at affidavits, to confront witnesses, to testify on your own behalf. None of those things were constitutionally required in many states until after the state laws were changed in response to ICWA, which came out in 1978. So it's ironic that there are constitutional challenges to the validity of ICWA, given how much it is rooted in constitutional remedies and corrections. So the first big argument is that ICWA goes beyond the scope of congressional powers in Indian affairs. And as Ambassador Harper mentioned, congressional powers in Indian affairs are plenary. We normally trace those powers to the Indian Commerce Clause, but we also trace them to the treaty power, to the Property and Territory Clause, the Supremacy Clause, the Necessary and Proper Clause, and perhaps something that opponents to congressional power often overlook. The trust responsibility itself is actually a source of congressional power to regulate Indian affairs. The second argument is an equal protection argument. And the argument here goes that when Congress creates classifications rooted in Indian status, some statutes say this law applies to Indians who are members of federally recognized tribes. Some statutes say this statute applies to Indians who have a certain blood quantum. And some statutes say this act of Congress or this federal program applies to all, quote, Indians. And there's a lot of hand-wringing and hemming and hawing about the constitutionality of those provisions. Now, the U.S. Supreme Court to date has not really questioned those classifications. In 1974, the Supreme Court said that so long as a classification is rooted in the trust responsibility that the U.S. possesses in relation to Indians and Indian tribes, then that classification is valid. It is not to be subjected to strict scrutiny under the Fifth Amendment, or in the event that a state adopts this classification under the 14th Amendment. So this has never been seriously challenged, and I want to point out that the Constitution itself actually mentions Indian tribes and Indians, the only ethnicity or race mentioned in the Constitution. And it strongly suggests by its very structure and this text that somebody has to define who an Indian is and what an Indian tribe is. And it seems likely that Congress is, at least in the first instance, has the power to do so. The third main argument is this notion of commandeering. This is or should I say anti-commandeering. This arises under the Supreme Court's gloss on what the 10th Amendment to the Constitution means. You might know the 10th Amendment, which says that all powers not delegated expressly to the federal government are reserved to the states. And for many decades, I would even approach 2 centuries, the court didn't know what to do with the 10th Amendment. And they finally consolidated around a theory that what it means primarily is that Congress cannot commandeer the legislatures of states in order to force them to move forward with federal prerogatives. So the Indian Child Welfare Act requires states to do lots of things, primarily state courts. Children can't be terminated, the parental rights of Indian families in relation to Indian children cannot be terminated absent, for example, active efforts by a state to try to reunify the Indian family. This one in particular is one that the Fifth Circuit decided to strike down. And what I mean by that is, keep in mind, this was an en banc decision of 16 judges, and they split 8-8 on this question. There is no majority opinion or position of the Fifth Circuit other than this is unconstitutional. Primarily what it means, the active efforts requirement says that state courts cannot terminate parental rights without a showing from the state agency that there was active efforts, for example. And the Fifth Circuit seems adopts a position that this commandeers the state legislature somehow. I would add that the Section 5 of the 14th Amendment is a pretty significant extension of power to Congress to remedy civil rights violations, to ensure due process and equal protection of the law, and to make states comply with federal statutes and federal prerogatives. And it seems there is no discussion whatsoever of Section 5 in the Brackeen decision, which I find kind of strange. And I'm hoping that that actually comes up to be an issue if this case is granted by the Supreme Court. The fourth issue is the non-delegation doctrine. Those of you who follow constitutional law might recall that the non-delegation doctrine used to be used by the Supreme Court as late as the New Deal era to strike down acts of Congress that were designed to respond to the Great Depression on a theory that Congress cannot delegate its legislative authority to other agencies of the federal government or anyone else. There are provisions in ICWA that requires state courts to follow the placement preferences of Indian tribes. Those placement preferences show up whenever a child is removed from the home and put into foster care, and also for an adoptive placement, a permanent placement. The statute says that if a tribe adopts rules that say things like, which ICWA actually says as well, but if the tribe adopts a rule that says first placement preference is to tribal members, second placement preference is to other Indians, et cetera, the state court must follow that. And the Fifth Circuit addressed this question. State of Texas lost on this question, but the court concluded that this does not violate the non-delegation doctrine. And the last question is one of standing. Judge Costa wrote it as one of the Fifth Circuit judges who wrote a concurring and dissenting opinion in the Brackeen case. I guess they're all concurring and dissenting opinions by definition because all the main questions were decided 8-8. But his opinion starts with a really important and poignant point, which is all of the adoptions at issue in this case involving the 3 foster families that have brought a claim alongside the state of Texas are complete. No adoption, no child, no Indian family, no family will be affected by an outcome in this case. Now, normally that would suggest that there's no case to be had, and there's no finding that this is a case that is likely to recur, although it's very possible that is the case. Texas and other states can't bring equal protection claims on behalf of individual American citizens, and it's hard to see any kind of case in controversy at this point. Nonetheless, the Fifth Circuit concluded, a large majority of the Fifth Circuit concluded there was still standing to hear this case. Quite ironic. And I'll conclude there. We'll have a lot of discussion more about the Constitution, but this is just sort of a brief survey of the main constitutional issues in Rakhine. Thank you, Mr. Ambassador.
Yep. Thank you, Professor Fletcher, for those opening remarks, really framing nicely some of the key questions and issues before the court in Burkina, but also framing them for the larger discussion of what these questions are. So I was going to turn to Professor Rees next. Professor, one of the things about the plenary power doctrine, congressional powers, is it's a sort of a mixed blessing. Because on the one hand, it gives Congress the power to break treaties. It gives Congress the power to terminate tribes. But on the other hand, it gives Congress power to pass the Indian Child Welfare Act. So anyway, I don't know if you want to talk about that or the other issues in Burkina, but the floor is yours. Welcome.
Yeah, no, thank you. Thank you so much for having me. I'd be happy to speak about that. I actually think that a mixed blessing is a good word for it, but as I've puzzled over it more and more, I actually think that plenary power and also some of the non-delegation sort of questions also raised by this case also illustrate sort of one of the greatest, I think, founding failures when it comes to the Constitution and Indian people. And that is that tribal governments themselves are not actually included in a way that would have really made sense. And I think that that is part of this sort of looming thing in the background with not just this case, but lots of cases, is all of the power and representation that tribal governments don't have in contemporary American society, despite the fact that they have all of this responsibility over self-government, and that they have this important political status that they are a part of the American family of governments, such as it is today, responsible for, administering justice to American citizens. They're integrated, but not in a really peculiar way that I think was, or not, I don't think that we very much know, I think was not planned for. Tribal governments, there are 574 federally recognized tribal governments. Of all of those, 21 of them have a reservation land base that is bigger than Rhode Island, right? So, and Rhode Island gets 2 senators. So there's these questions about who gets to decide all of these important questions over Indian affairs, and the options are not the full spectrum of what they should be, because tribal governments were not given a seat at the table or contemplated in our founding document as equal governments within the system. I often think back to this line. I pulled it up because I'm a law professor who does such things, that in Worcester versus Georgia, one of the sort of founding cases in Indian law that really affirmed tribal sovereignty and domestic dependent nationhood within the United States, and that state laws wouldn't apply over tribal government territory, went through all of that, really great fanfare. And then Justice John Marshall says, but the exercise of the power of self-government by the Indians within a state is undoubtedly contemplated to be temporary. This is shown by the settled policy of the government in the extinguishment of their title, and especially by the compact with the state of Georgia. It is a question not of abstract right, but of public policy. I do not mean to say that the same moral rule which should regulate the affairs of private life should not be regarded by communities or nations, but a sound national policy does require that the Indian tribes within our states should exchange their territories upon equitable principles or eventually consent to become amalgamated in our political communities. So, right there, even at the inception of this doctrine of tribal sovereignty that we have absolutely made the most of, is this contemplation that it will not last. And so tribal governments have, I think, and Native people, I think, in surviving, both, defied this expectation and created these complicated, not just political and legal questions, but also structural questions about the United States and how we govern ourselves and who has power and who doesn't, and the structures that we allow as workable, and why we have 50 recognized state governments, but not but nothing for 574 tribal governments. They at best just get to lobby Congress and get all of the laws that govern their affairs passed effectively, as lobbying activities do, just like any other private citizen. I think that is something that even aside from the legal issues themselves within Brackeen, is just highlighting this problem underlying the Constitution itself.
Thank you for those comments. I think there's a lot of wisdom in there. For those who are less familiar with Indian law, I think Professor Reese makes a point. Also, it also points to the fact of the complications of Indian law. If you take a federal courts class, it deals with some of the most complicated issues because they're struggling between, what rights and powers that the state have versus what rights that the federal government has. And Indian law says, well, we're going to have all those problems, plus let's throw in a third sovereign, and then you divide up the powers and rights. And so it just adds a level of complexity and complication. So I'll now turn it to Professor Rolnick for basically opening remarks on the Constitution and Native people.
Thank you, Ambassador. Oh, can anyone hear me, first of all? Yes? Okay, thank you. I'm really delighted to be able to be here with all of you. So just real quick, I thought I would just dig into the equal protection question. I'll explain why, but I wanted to respond really quickly to some of what Professor Reese says. I think all of that is true. It made me think about, again, the importance of treaties. So which is to say that if the Constitution is not structured such that tribes have a formal role besides today lobbying from the outside in determining what happens with Indian affairs, maybe the way that that was handled prior to the end of treaty making was that they had a direct treaty relationship and therefore a chance to be involved in what those decisions would be. So it just suggests, especially in light of recent cases, why paying attention to treaties as the undergirding of it and the way those treaties were understood is incredibly important now that we have a structure that doesn't include that going forward. So just pivoting a little bit and talking more directly about Brackeen, I thought I'd talk about the equal protection piece of it. So equal protection is so the challenge is that Congress can't be legislating, and there's some different ways that this is put forward with regard to Indians without it being an illegal racial classification. And in terms of what the Indian Child Welfare Act is supposed to do and what it's aimed at and who it's aimed at, that is a ridiculous distraction, right? That argument is such a side piece of what it is that ICWA is supposed to do. But I think that the equal protection argument is really the emotional core of the people who challenge ICWA. So there's many different legal ways in which the statute has been challenged, but it really strikes me the persistence of the challenges, right? So there's lawsuit after lawsuit. We see this one getting up much higher toward the Supreme Court, and we don't see the Indian Child Welfare Act very often going before the Supreme Court, but we just had the adoptive couple case not that long ago after years of silence on this issue. And beginning in that same case and spinning out of that same case is where you really saw the pickup of district court level challenges to the idea that the entire statute violated the Equal Protection Clause. And they just keep coming, no matter how many times those district court cases lose. And I guess when I look at it, the only the only areas in which you see sort of comparable money and energy spent on those kind of challenges are things like challenges to the Voting Rights Act and challenges to affirmative action. So there's a really concerted, well-funded collective effort to take down the Indian Child Welfare Act that doesn't make a whole lot of sense when you look at how little the legal community and the public at large engages with Indian issues and Indian law more generally. And so I think that that the equal protection challenges sort of say something about where the attacks are coming from. And although Native people are completely differently situated legally than any other group that's been racialized in the United States, the thing that is driving some of the attacks on the Indian Child Welfare Act, I think, is not actually that different than some of what is driving equal protection-based challenges to other rights of other racialized groups. So for those of you who, we've got a giant audience, and I don't know how much people have been following the case or the challenges or really understand what the Indian Child Welfare Act is about. So I'll try to distill it a bit. But the provisions of the Act can be divided, I think, into two chunks, right? So one set of chunks are the definitions. So the Act applies to Indian children and Indian parents. So you've got, sort of backing up a little bit, this class of indigenous peoples in the United States that the Constitution clearly contemplates that Congress can deal with, and that the lexicon they use is Indian, and that Congress can define that term and that it might be defined in different ways. So we've got this term there, and the statute applies to Indian kids and Indian parents. And so it has its own definitions. There's not one uniform definition across federal law, but the Indian Child Welfare Act has one. So for the definition of Indian child, it just talks about children who are either citizens of a present day tribal nation or eligible for citizenship and the child of someone. So when we talk about how sort of generational or ancestry, we're looking at one generation removed in the way that this definition works. So there's other definitions across federal law, but this one only allows you to go back one generation. And just in terms of why that definition makes sense, often we're talking about babies. And so I'm a law professor, I study this, but I do like to say I'm also a non-native parent of Native kids. And so for all the people in the audience who aren't Native and who haven't dealt with tribal enrollment procedures, there's paperwork involved and there's steps. And so babies aren't automatically just sort of magically citizens necessarily. Somebody has to do that paperwork. And so when you talk about a baby who isn't a citizen yet, but is a child of a citizen, that's most babies because the paperwork hasn't been done yet. And particularly with babies who are maybe living in a community or with parents who are kind of disconnected, it certainly isn't going to be done. So it's really obvious if you think about it, why you would define the category that way. It doesn't reach that far. So that definition is fairly narrow as far as Indian definitions goes. The other category are the adoptive placement preferences and the preferences for foster care placement. So that is, the Indian Child Welfare Act also says that once you've got an Indian child who this act applies to, that child, if they end up in state court, right, there's provisions that allow the tribe to take jurisdiction, provisions that allow the tribe to intervene, but if they stay in state court, then the state court has to follow certain preferences for where they're placed in foster care or adoption. And the first set of preferences has to do with relatives, which actually includes non-Indian relatives of the child. So relatives come first, and then tribal members, so other citizens of that same tribe, and then other Indians. And those ones are a different category of classification because they don't talk about citizens of the same tribe. They're looking at Indians as a category of other people who might be citizens of other tribes. And the other big area in federal law where this shows up is in the definition of tribes and the federal government's criminal jurisdiction powers, which is, it's very clear that those powers extend to Indians who are not citizens of the tribe that we're talking about in terms of its power. So there's a couple areas in federal law where Indian talks about what we usually call non-member Indians, so people who are from other tribes who are also in the Indian category. And so the first set of definitions is, I think from a law perspective, it's like pretty easy to defend, right? So it doesn't really use multiple generations of ancestry. We're just talking about parent to child. And mostly it's looking at children, it's referring to citizenship in a tribe, and it's looking at children who either are citizens or basically are about to become citizens once the paperwork is done. They have to also be eligible under that tribe's citizenship rules. So it's really not very far from a rule that just looks at tribal citizenship. And in 1974, when the court upheld Indian classifications, it really did so by pointing to the idea that usually they are about citizenship. So the easiest way to look at a constitutional Indian classification is one that focuses on citizenship. So those ones are pretty easy to defend. They're not anything near the definition in federal law that sort of taxes your brain when it comes to the equal protection challenge. The second set, the placement preferences, are the harder category. I don't think that courts or scholars really spend as much time trying to defend the reason for a sort of a other Indian category. And I wholeheartedly agree with what Professor Fletcher said at the beginning, which is this is a category that is elastic. You may need to define its boundaries differently for different reasons. And it's clear that Congress has the power to do that. And the court has made clear that it only needs to be rationally related to Congress's power. So I think that the Fifth Circuit is correct. Or, well, the opinion that says that these are constitutional is correct in suggesting that there is a basis for placing a child in this situation with another Indian family. There are reasons to assume that those families would have an understanding of what it meant to stay connected to a tribe, would be better able to facilitate that child's connection to their tribe. So there's a lot of reasons why that might be true. You don't see those articulated as often, so that tends to be, I think, the weaker, the challenges focus more on those categories. And I think what's interesting about those categories is it's really clear that Congress means for Indian in some situations to include these non-citizen Indians, but the court doesn't tend to take up that question. And to the extent that the court has taken it up, there's still good case law on the books that suggests that that category is a problem for the court. So that's the most kind of confused and difficult area, I think, for a lot of people to understand. But what I think was quite striking about particularly the district court case here is the way that they struck down the easy category, right? So I don't think the Indian Child Welfare Act definition of Indian child is a very hard one to uphold under any version of what counts as a political versus a racial category. But initially the district court did strike it down in what I would call pretty lazy reasoning. So they just cite to Rice versus Cayetano, which is a case about Hawaii, and sort of say, well, we see the use of ancestry either in the tribe's rules for who can be enrolled or in the definition by looking at the parent of the child. And that is like a red flag for us that ancestry is race. And the citation for that is Rice, which is a case in which the court said that sometimes the use of ancestry can be a cover for race, but not that it always is. So we can follow up on this later. I don't want to take too much time at the beginning, but one thing that I want to illustrate here, sort of show you a bit more about, is the Rice case was not about recognized Indian tribes. It's about Native Hawaiian people, although it is about Congress's power and the role of states in legislating with regard to indigenous people more generally. And what you see there is that where the category of indigeneity is defined, not using the word Indian, or defined with too much reliance on counting the connection of people over time to original inhabitants who were colonized. And if you do that through ancestry by using someone's ancestors as a proxy, which we often do because we don't have another proxy, that's where the court tends to react as if it's a problem. And although we don't see it come up in Indian law that much because most of the categories define Indian with regard to citizenship, it has been a real problem for indigenous peoples in Hawaii and the Pacific Islands. So there's a number of cases that I think sort of fed into the district court's decision in which Rice was used to strike down legislation with regard to indigenous rights outside the context of Indians. And that, what I will say last, is that to me is really a consequence of the way that we've kind of backed into this idea that political classifications are one thing and racial classifications are another thing, and that to be a political classification, it has to be non-racial, which I don't think was actually what the Mankari court was suggesting. And then all kinds of stuff happening on the idea of racial classifications that really has nothing to do with Indians. So in this sense, the sort of incredible pushback against the Indian Child Welfare Act and against indigenous rights in other places is, I think, in a lot of ways, just a tool to eventually come back and attack something like Black voting rights somewhere. So this is, I think, Indian children being caught in the crossfire or something that isn't necessarily about them. And it becomes, quite difficult to identify that and defend it.
Thank you, Professor. So now I'm going to turn it over to Chase. Chase I'm really glad he's on the panel here because he's one of these folks that is in the trenches fighting the good fight. And I think all kinds of Indians versus the Constitution happens in those kind of places. So Chase, you have the floor.
Yes, thank you, Ambassador Harper. I just want to say that it's a leon betiki lila dayawa ualo oyate wotakuye woglaka lila wopila tanka Ambassador Harper, Addie Rolnick, Matt Fletcher, Professor Reese. It's just an honor to be here. I've followed Matt Fletcher for a while. I met Ambassador Harper while I was in law school. I grew up on the Standing Rock Reservation, the Standing Rock Nation, and I was raised by my mother there. From the time I was born in the Black Hills, which are kind of like the spiritual epicenter of not just the Lakota Nation or the Oceti Shakoni, but of many different tribal nations that even predated our presence here. But we're taught from a young age, those of us who are Oceti or Lakota, that we have that we are the predecessor sovereign, that we actually recognized a fledgling United States, a much younger sibling, a much very much foreign and new coming nation of immigrants, when we treated with the United States several times. When we talk about the formation of the Constitution, or when the founding fathers were drafting the Declaration of Independence, the European Christian heteronormative imagination kind of set the framework that we inherited, not that much long after the formation, the conception of this country. But we were taught that we come from this land, we originate in this hemisphere, despite what academia tells you about the Bering Straits or any of these other theories. This forms the foundation, the spiritual foundation of what we call sovereignty, or what some people would call tribal sovereignty. And to speak about the importance of the United States Constitution, this is what I'm getting to, is that this is the Constitution Day. For everybody who has the opportunity to join us today, you should know that indigenous nations hold the United States Constitution to be sacrosanct. When American, usually males at the time, came out here and wanted to treat with us for peace, because if you look up Red Cloud's War, or if you look up the formation of the Bozeman Trail, you will find out that we defeated the United States military multiple times. So not only we would not have been contemplated in the framers' mind in the United States Constitution, because they hadn't asserted themselves in our homelands, in our minds, in our presence yet. We were as then unsubordinated. The title of our talk has the word subordination in there, and unless you are indigenous, you will go through law school only hearing that Congress has plenary authority over federal Indians, over federal Indian tribes. Anybody who is not federally recognized pretty much doesn't exist for purposes of protection of the United States Constitution and the colonial or federal. Those are the same things to us out here. And I just want to demonstrate that the Constitution for us, because of the Supremacy Clause, I was taught as a young kid that treaties are the supreme law of the land. And that's, Article 6, Clause 2, which we mentioned as, something very, very important in legal circles. But it's also extremely important in the lives of Indians, in the lives of indigenous nations who very much know that the Indian wars have not ended. Yes, we as lawyers, we know they've changed forms to different arenas, but it's still very much physical. If you look at what happened at Standing Rock, that's the time that I was running for the United States Congress. And after Trump won that year, that presidency, I began to be more just on the ground. And what my intent was to provide a spiritual and legal foundation, not only for the indigenous reclamation of that land, that we hadn't been permitted to assert ourselves in any juridical, economic, social, political, any other manner in this particular chunk of land where those camps were at, the Ocheti Shakoni camps. But it was also to express my ideas, or my not just me alone, but the realization that our constitutional rights, our birthrights and our inherent rights and our treaty rights, those rights were on the table. They were at risk, and they still are. Our rights to peaceably assemble were completely run roughshod over. Our rights to speak freely. The United States, the Army Corps of Engineers created something what they called a free speech zone for the protesters that were there at Standing Rock. Our rights to be free from illegal searches and seizures. It's not just, Edward Snowden and Chelsea Manning, but right there at Standing Rock. It would be empowering for us who are going to inherit this legacy, this very much live controversy of what the Constitution means to us, to dive into Indian law, federal Indian law, because it's not just at Standing Rock. I moved from Standing Rock to the Pine Ridge Reservation, where you could watch Robert Redford's film Incident at Oglala to find out how these constitutional, these sovereign challenges, we are constantly trying to push back against the tide of colonialism, which is based in the doctrine of discovery, but was expressed by people like John Marshall with the concepts that they invented. These cats just straight up invented these things, like implicit divestiture or domestic dependent nationhood. That doesn't even exist. Like, that's an oxymoron. But out here in Pine Ridge, fast forward from the days of the 1970s, I'd encourage you to look that up as well. When I moved here, COVID happened, and the tribal governments instituted these checkpoints because, according to our inherent understanding and our treaty understanding, we have a right to regulate who comes in and out of our territory. And Governor Kristi Noem, the governor of South Dakota, completely flipped the switch, and she issued a threat. Said, if you, meaning the Oglala Sioux tribe and the Cheyenne River Sioux tribe, do not take down these checkpoints within 48 hours, you will suffer legal action. Nobody here knew, for us, that's why we're surrounded by this kind of violent colonial mentality, and where there are not a whole bunch of native people, sometimes you don't see that. But if you live in, for instance, the Dakotas, you have a governor who's issuing threats to tribal governments, and the people on the ground are thinking, hold up, she's going to show up with the National Guard. And on this day, the day that where the 48-hour ultimatum expired, about 1,000 people on the Pine Ridge Reservation showed up to each of these border checkpoints with their guns. They were fully armed, ready to defend our inherent authorities as the predecessor sovereign. So these are not just theoretical. These are not just things that we get to study within the context of our disciplines. These are taking place in real life, and they're very much requiring of us to tell the truth amongst each other, especially on Constitution Day, because we are taught that the Constitution is the supreme law of the land, treaties are the supreme law of the land, and we are very much invested in furthering our understanding and our ability to evolve as a country. And we're in the moments of deconstructing the cultural mythologies that have defined the American identity over the last 240 years. And the fact that we're here able to share all this is testament that we are making progress. I want to say that I've been following the work of Ambassador Harper, Matt Fletcher, especially with relation to the Brackeen case, because I do a lot of work within the ICWA context, but not in the courtroom anymore. We are trying to empower tribal nations individually through, Title 4E of the Social Security Act. So we've all been busy. It's really good to see you guys, and Godspeed. Take strength, take courage, and carry on. Thank you for having me on.
Thank you, Chase, for those and your remarks. Talking about the Constitution, and this day is about celebrating that Constitution.
Yes.
But what's interesting to me is that when the McGirt decision came down last term, and it was based on a treaty provision, there were so many commentators antagonistic to the McGirt decision that said, "How are we listening to all these old treaties? These were almost 200 years old." So we venerate one document,
Right.
critical document that states the laws of the nation, but another one that is maybe not even that old, as old as the Constitution. We don't have that same veneration for it. We use its age as a mean for criticism. So I just think that's interesting. I do want to say, to remind everybody, that we do have a question and answer box. Please use it if you have any questions. I see there are some in there. I would also ask you to keep your questions short, so that I can actually read them. So one interesting thing, maybe we'll just do a short comment period, 1 or 2 minutes from the panel, and then we'll go to questions and answers. And maybe back to Matt Fletcher. Matthew, one of the interesting things, and this came to mind when Professor Rolnick was talking. It's very interesting to see that Judge Duncan, who was the principal opinion antagonistic to ICWA, basically used a rational basis test to strike down, to seek to strike down on equal protection grounds the family, the Indian family, and he said that there's no rational basis because it's a different tribe. And what that told me is that these folks have no idea what Indian country looks like, because if you're Anishinaabe in your neck of the woods, or if you're imagine a Cherokee citizen to an Eastern Band family. I mean, there's so many related tribes, and it could be a distinct tribe. Anyway, I just wanted to see what you thought about that equal protection part that Professor Rolnick was talking about.
Yeah, that position that the use of Indian tribes from other tribes, or Indian tribal members from other tribes, doesn't fulfill the rational basis test. It doesn't fulfill the trust responsibility. Fails to acknowledge that almost every state routinely discriminated against Indian families for purposes of foster and adoptive placements. As I said at the outset, 85 to 90% of all the Indian kids are placed with non-Indians. Many states refused to license Native people to be foster parents. They still do. And it was really just very ahistorical. It's an argument that, as Professor Rolnick mentioned, came up in Duro versus Reyna, where tribes are trying to say, look, we should exercise jurisdiction over all Indians within our territories because there's a lot of intermarriage. There's a lot of commonalities between Indian people. And the court, in that case, Justice Kennedy wrote for the court, just dismissing all of that as if it were completely meaningless, on the very formalistic view that if you're a member of one nation, you are not a member of any of that. If you're not a member of that nation, you're nothing to that nation. And that's just not how Indian country works. And so I would also add that this is a really hotly contested issue in play in one of the 3 adoptions that is before the Supreme Court right now. It's not the Brackeens and it's not the Librettis, it's the Cliffords. In that case, a tribal citizen grandmother, an Indian grandma, adopted the child. But if you read the pleadings, you wouldn't know that. The other side is arguing that the grandma had her foster license revoked. And in reality, she never had her license revoked. And she is a licensed foster care person. And she also adopted the child. And it's these kind of stories that play to an audience that is looking for and is receptive to the notion that Indian people are not competent adults, they're not competent families, and that they are effectively foreign to the American nuclear family. it's a very disturbing argument, and but it is absolutely couched in terms when you get to the court. It is a projection of a coded signal of racism.
Thanks, Matthew. And so, Elizabeth, do you have any thoughts on that? On this, this equal protection is, is you noted. I mean, others have noted it's just always present, and it's always getting challenged, and maybe we get a final answer in a positive direction. I think part of it is that it underpins all of Indian law. I mean, and there's this presumption that it's constitutional, and we have, as Morgan itself said, we have 25 USC, an entire title that is about Indians. Do you have any thoughts about that? These continuing challenges?
Yeah, no, absolutely. And I think I saw it in the chat on some of this question, because this is a question about tribal sovereignty, about race, about political identity. I saw in the chat someone, raising questions about the boundaries between political identities and racial identities, and the ways in which, race is obviously constructed. What is an Indian anyway? I've been, my ancestors were native, I guess, the native people of New Spain, and then the native people of Mexico, and then I guess now we're Native American, and yes, I have some indigenous identities in common with other people who are indigenous, but that's, pales in comparison to the very real tribal identity that I have, and the citizenship that is, and the language and the history and the all the things that make up a nation and a community that are very real. And that is Nambe Pueblo, where I was born and grew up in. And that's the thing that's real. And an Indian itself is somewhat kind of a constructed thing and an American thing anyway, and that also complicates things. What I think is also an important part of this conversation, that if it happens, I will do the equivalent of flipping a table in outrage, probably, is that I think there's also this story of how tribal governments themselves were raced by the United States. So, not just, of course, race is politicized, but also these political entities were raced, and have been, thought of as, if you think about it, tribal, like we call them tribal governments instead of just the pre-colonial governments. A lot of that stuff, is very latent with this ugly history of seeing them in a certain way. That's part of this colonial project to push them aside and delegitimize them. And what I think is this horrible irony too, is that, of course, tribal governments, like many other governments across the country, had processes for naturalizing citizens, right? For having people marry into their communities, and then having certain rights within that for becoming a member of this political community. But, it's the United States government that, in another early Indian law case, denies tribes the right to do that and refuses to recognize someone who has married into an Indian tribe and is saying that he ought to be treated as an Indian under the purposes of federal law. And, the Supreme Court says, a white man cannot become an Indian, right? So they're part of this is, which is the part that I will flip a table if this happens, is that the racializing and limiting of the freedom of these political entities to do what they want with their citizenships in ways that would have also made this, proxy question more complicated, is also something that the Supreme Court created itself. So, if we get an opinion that says something like, tribes can't do this because really this is all just race, I will have the sense of like, you did, part of that was also part of the story of conquest that you did, because you also failed to fully see these governments as things that were allowed to freely alienate citizenships, because you saw them as racialized entities that couldn't, as the Supreme Court says, adopt non-Indians. So that racializing that's within the doctrine of law itself and that the court is doing in these old cases is also playing, I think, an outsized role in the creation of the history and the contemporary rules that everyone's operating under.
Yeah, that's very interesting. And, it reminds me when you're looking at this question that, of course, the freedmen of the 5 tribes, these were former slaves of some of the tribal members of the 5 tribes in Oklahoma. They were by treaty made members of each of those tribes, and they are by definition without Indian blood. And so, and that's contemporaneous with the adoption of the Equal Protection Clause. So, how does that impact the conversation on these questions of race versus politics? Professor Rolnick, I don't know if you have any thoughts on that, but also there's a question in the chat about Professor Fletcher's ideas on Section 5 of the 14th Amendment, and whether or not that's the remediation part of the 14th Amendment as the basis, the constitutional basis of making these laws. And the chat asks whether or not given the makeup of the court, that could actually lead to the weakening of rights of all vulnerable people. I don't know if you have any thoughts on that or on this race politics.
Yeah, so I don't disagree with anything that Professor Fletcher said in his answer to that. I think it's interesting. So to the extent that we have an audience that doesn't follow Indian law as much, within the sort of federal Indian law legal community, it's been recognized for a long time that the thing to do is to keep things away from the court because it's not going so well, and that's been kind of a strategy for a long time. I don't know that outside of Indian law that's been acknowledged as much. So yeah, in a way, and particularly on questions that tread anywhere near race. And I think here again, ICWA is not a law about race, but it's been sort of stuck in there. Anytime that stuff gets before the court, there's a chance it's going to go badly, and there's so many ways in which those questions have gone badly, and so there's a real risk to that. I think a risk to other groups, but really also a risk, and sort of more immediately a risk to what is going to happen with children and the rights of Native people generally. I think are more immediately at risk than how it will be used for other groups, but there isn't really a choice because the effort to bring this before the court has been sort of relentless. So there's been a lot of ways in which the court has, in adoptive couple, I think the court pivoted away from kind of, there was like a haunting question about equal protection in the back of adoptive couple, but the court pivoted away from dealing with it, which most people breathed a sigh of relief at that because it didn't seem like the way that the court would deal with it was going to manifest much of an understanding. So I am very nervous when any of this stuff comes before the court, but also if the attacks are being funded and pushed, there's no choice but to sort of defend them in the most legible way possible. One of the things I think is really difficult is you've got to defend those attacks in a way that the court can understand, and the court has shown sort of, I think, a limited ability to really have a whole understanding of the way that this works. And sometimes that means that they have to be defended on narrow grounds, which then can ricochet, like for other groups, but also for other contexts of Indian classifications. If you hone in on the Indian child definition as the only kind that works, then you make vulnerable the adoption preference provision because you've defined what's legal in a very narrow way. I guess what I wanted to respond to here, there's a number of questions in the chat about kind of what do we do about this? So the court frames things a certain way. How do we push back against this? And so I would say two things. One is so as lawyers, right, you have to tell the story in a different way. So all of the people who spoke it today have started in a very different place than they were maybe invited to start at the beginning, and you tell a story differently. And the court in this area is so adept at kind of telling a very narrow story. So when you see a decision of the court, don't pick up the box that you're given and assume that that's the only way. If you start with, well, this might be a racial classification, let me look at the Mankari rule, you're already too narrow. And so I think just that as advocates, part of the art is to sort of start to tell the story in a different place. And when you tell it, I mean, that's the beauty of Indian law, is how many times advocates have been successful in telling the story in a different way and actually changing the outcome. But for people who are not litigating, this is easier than you think, right? So read so Professor Fletcher and Professor Reese said this, look at what's really going on in the cases, because the hair pulling about these sort of difficult issues, like how do we figure out who's an Indian, who's a real tribe? Are these people really part of the tribe? Do they have no right here? Like, that's not actually an issue. Are the opponents they have a whole website, right? The Goldwater Institute, that talks about these babies that have died in foster care, and the idea is that tribes are refusing to let the children be adopted by people, and then they're sort of dying at home. But if you look at the circumstances of, as far as I can tell, every case that sort of ends up in an Indian Child Welfare Act challenge, it's not about abuse that the kid is suffering. They're all stories of some kind of what we might call kind of neglect or poverty, right? So sometimes a kid is hurt because they're left in someone's care. Sometimes there's sort of a drug or an alcohol issue. Sometimes they're left with a babysitter because there is no other babysitter, and then the baby gets harmed some way. These are not stories of parents abusing their children. So these are all stories that are exactly the same as the reason that ICWA was enacted, which is you see removal, instead of investing in communities and supporting parents so that they can raise their children, the first chance that anyone gets, they go take the children and try to put them in a white home. And that's been the story for a long time that we're trying to counteract. So that is still the story of all of the cases that get before the court. And then this question about, is this, so Professor Fletcher mentioned the way that the grandmother was framed, and that happened in adoptive couple too. So the court said, well, we don't have to deal with this because there's no one trying to adopt the child because one person was the child's dad. So normally when you're the dad, you don't have to try to adopt a child. And then the court manages to write him out of the case by saying, well, there's no one actually seeking to adopt the child or to take the child because they defined him out of being a dad when he said, I don't have to do this because this is my kid and I never gave my rights up. So there's just a lot of gymnastics in these opinions that make things seem very difficult. Professor Reese was talking about this too, but in terms of race is a construct, citizenship is a construct too, right? So that you have communities that are political communities who have decided in a lot of different ways how it is that people belong. And it's not really been hard. And if you are in most of these communities, there's not a question about who belongs and who doesn't, or who's part of it, or who's under the jurisdiction or who's not. They're not actually difficult questions in practice. But when we try to fit them into this weird construct, then you see the court, mostly these are probably coming before judges who've sort of never engaged with this, with actual babies in reality or actual citizenship rules, thinking that it's a really hard question. So what I would say is, if you want to resist some of that, just kind of pay attention to what actually happened in the cases, as opposed to the construct that people are fretting about.
Okay, I'm going to get Chase back in here in a second, but I want to get through some of these questions as well. There was two questions from G. Scarcelli. First, are tribal governments free to determine who their tribal members or citizens? I'll say yes on that. And then, can Congress respond to equal protection challenges by giving tribal government interests in the adoption of children, something like how other countries can assert their interests in the adoption of their citizens? Does anybody want to explore that question?
I'd be happy to. That's exactly the theory of ICWA. Tribes are parties to cases involving Indian children. Automatically, they have the right to intervene. They have the right to seek transfer of those cases out of state court into tribal court. And absolutely, tribes have the power to decide who is a member of their tribe. And that's what was really heartbreaking about adoptive couple in 2013, is the court talked only about blood quantum and refused to discuss the very real social, political, and cultural relationship that child and her family had with the Cherokee Nation. They just refused to engage with that whatsoever and caricatured tribal membership as purely a racial ancestry question, which was wrong on the outset, but completely unsurprising given the constituency of the court and the way the case that was framed. I wanted to add something else on this question of equal protection. I have very serious doubts that the court is going to take this very seriously, and I'm sure I will come back to eat those words. If ICWA goes down, all of Indian country criminal jurisdiction goes down, all of it. The Major Crimes Act, the Indian Civil Rights Act, the Indian Country Crimes Act are all predicated on application to, quote, Indians. There's no definition in the statute as to who an Indian is, and you can absolutely be prosecuted by the federal government under these federal statutes by virtue of being an Indian, even if you are not a tribal member. And I have a hard time believing this Supreme Court or any Supreme Court outside of ex-party Crow Dog would find that that is somehow is unconstitutional. And I wanted to point that out because that's a particularly important issue that probably will not be openly discussed, but will always be in the background of this Brackeen case.
Yeah, well, I mean, that is the hope in light of the potential consequences of Brackeen. Chase, on this question of who is an Indian, you know, you live up in a part of a country with a lot of reservations. What are your thoughts on that? And, you know, how hard is it to determine who's an Indian, who's not?
That's a very important question. It's why we created the name, the cheekiest name of a website ever existed, Last Real Indians, because every single word of that name is, you know, subject to open. It's subject to interpretation. It's subjective. We do retain the authority. You know, one of the panelists mentioned something about incorporating new people into, you know, your gene pool or your quote unquote tribe. This is for us here in this part of the country. We have a ceremony for that. It's called the Hunka ceremony, and you know the concepts of like blood quantum. When you think of tribal membership or tribal citizenship, the first thing that comes to mind is, you know, like it was highlighted with the Mashpee Wampanoag and President Trump at the time. They pull up old footage of him saying these guys don't even look like, these guys ain't Indians, they ain't natives, they don't even look like natives. So all of these questions, and yes, race is a construct. I haven't got through the whole. It's called History of White People. It's a very good book. It kind of outlines the origins of race as a concept, connecting it to the slave trade and everything else. But all of those ideas kind of infected or informed the concept of the federal Indian. But the federal Indian is a very real corporate person. It is something that we in real life attach ourselves to because there are certain immunities, privileges, rights, benefits that are attached to, you know, upholding that reality, which is coming straight from the federal government. And it's very dangerous because there are other tribes, like at line 3, I saw in the comment section, yes, the reason why they assert jurisdiction over us anywhere in treaty territory is because that's what we do. We're telling ourselves a lie, and we're upholding that lie militarily, institutionally, and so forth. We just don't have the space to kind of tell the truth to ourselves yet. But it will continue to be kind of thrown into the forefront because of who we are as indigenous nations. We can't ignore, you know, what we are or who we are, and continue to explore that and express that in different ways. Now, you know, thankfully, we're able to do that on a spiritual, psycho-intellectual level where we know that we're building bridges, that we're creating allies, because we do need help. When we think about who is an Indian, if you look at ICWA and the order of, what was it, the active efforts, you know, that tribe or that state courts are supposed to place a native child who by instance is usually being subjected to criminal justice contact because of poverty, which is, for us, it's almost like a status offense. There's a lot of, too many of our people are just born into that cultural manner, which results in these habits that in turn allow for our children to be contacted by the criminal justice system. Add to that, since Standing Rock, the big financial extractive complex. If you listen to Rebecca Nagel's podcast, I saw it mentioned in there, it's called This Land. She explores how big extraction, their big lobbies, their think tanks, everything else, they are very acutely aware of kind of the threats that indigenous sovereignty present to their hegemony or their hegemony, however it is. When we talk about, like, they also, there's certain forces that don't care about the strength of the Constitution. Fortunately, there is, and there's too many questions in the comment section, but thank you for offering them. It's a blessing that people like Ambassador Harper are on the board of ACS. And you have people like Mr. Feingold who are willing to bring in these different perspectives, because although we do retain the inherent authorities to say who is a member of our tribe, who is a citizen of our tribe, that doesn't mean that we're able to, like in the manner of in parens patriae, go. Yes, we do have ICWA. We're able to assert ourselves in these different places, but we're finding very hostile neighbors. And so in South Dakota, I'll finish with this last bit of stats. When I first got involved in ICWA work, it was because 9 out of 10 Native children that were taken by the state of South Dakota Department of Social Services, 90%, a full 90% were being placed in outside of that order of operations. We're supposed to be, next of kin, outside in the larger relative network of Native people, Native family, Native extended family, Native tribal specific areas, and then other tribes across, what is now the United States. You have state governments, state prosecutors, state judges that are completely antithetical to that. Like they are not interested in it. They're still playing cowboys and Indians from the late 1800s. And sometimes our judges are doing that too. It's always dangerous to go to the Supreme Court, but you get people who have contact, and I don't know Neil Gorsuch's like personal history, but he lived in Denver for a time. Ton of Native people in Denver. Like, the more we meet each other, the more we're proximate to each other, the more we talk, the more informed all of this jurisprudence is going to be from here on out. But 90% of these children are being placed in non-Indian homes and institutions. Over 700 a year are taken. This is when Native children in South Dakota make up maybe 10 to 12% of the entire child population. But in the Department of Social Services, a full 54% of children in state custody at any time are Native people. There's a really cool judge named Viken. I forget his first name. I only argued in front of him one time, but he was just amazing. But there was a state judge. He had to admonish a state judge named Jeffrey Davis, who placed 100% of Native children who came before him, placed them in non-Indian homes and institutions. So this is the kind of environment that we're contending with. I'll stop there. Thank you.
Thank you, Chase. So let me go back to we only have about 10 minutes left. Let me go back to the question and answers. Helen Nolan writes, under ICWA, emergency provisions of children removed from Indian homes are supposed to be returned once the emergency abates, and yet more than often than not, they aren't returned. And that coupled with what Chase just said, I wanted to see whether the panelists would comment about the continuing need for the Indian Child Welfare Act that we're just seeing even with its existence. You look, and I do also like the This Land podcast from Rebecca Nagel. It lays out some of the factual background on these families trying to adopt Native kids, including the Cliffords, where it's trying to happen with the grandmothers trying to adopt the child. But I wondered if any of you wanted to weigh in on the continuing necessity of the Indian Child Welfare Act.
Yeah, I would love to jump in. My sense is that in many states, the number of children that are being removed percentage-wise from Indian country is far disproportionate. In some states, it hasn't improved at all since ICWA. ICWA didn't solve poverty. It didn't solve the ravages of colonialism. So states are continuing to remove Indian children, sometimes at the same rate as prior to ICWA. And that's not necessarily a bad thing. It's not a great thing, obviously, but it's just the reality of the world. What happens in a typical case is there's a report to the police, and if the state acts, they remove the child, and within a few days they have to have an emergency removal hearing. And all that is a probable cause hearing. It's not even, basically, it's more likely than not than the child is in neglect. And that's at the point where ICWA kicks in, and the state court is supposed to say, hey, does anybody here have anybody reason to believe that, or reason to know that this is an Indian child? And it takes a little bit of time for the tribes to be involved at that point. And even sometimes, and it's true, the states do not ask the question. They don't comply with ICWA. I would say nationally, the compliance rate at that hearing is probably less than 10%, maybe less than 5%. And that's a serious problem. But in jurisdictions, as in some places here in Michigan, Washington State, some other places, even in red states like Texas, in the jurisdictions that do take ICWA seriously, the tribes and the state work collaboratively at that point. And there are a lot of amazing success stories. What we do know is that foster care is almost always universally bad for people. And as perhaps Addie or perhaps Liz said earlier, Indian country is not a fount of abuse. It is a question of neglect. It's the problem of dirty homes. People calling the police saying there's parties going on, and kids being removed because of allegations that may or may not be true, that it's all about this probable cause element. But once people are in the system and in foster care, that's where the real horrors happen. And that's really where the focus should be. So I'm totally in agreement with Helen Nolan that we should do everything we can to keep our kiddos out of foster care. All the science and social science studies suggest that in keeping them home as much as they possibly so as long as they're safe, is far better than any foster care, even with a loving and privileged family. And that's what we know so far. So it is absolutely is a useful thing.
Can I just throw in an answer
please.
to
Yes.
that? So I guess I just wanted to highlight, I think there's two other things in terms of thinking about the need for ICWA before we even get to kids coming into state courts that I think it's worth shining a tiny light on that's going on here. So one of them is just, so yeah, sometimes things are going on with kids where families need help, and sometimes, I think in a minority of times, the kids actually need to be removed. Most of the time, resources to the family would be the best thing, and that's just not how state systems at least are set up. They're not set up to help the family, they're set up to take the kids. And often someone has to do it, and someone has to kind of figure out the best placement. And so the sort of first question ought to really be, why isn't, and some people have asked this in the chat, like, why aren't tribes able to do this? And there's other stuff sort of before we get to ICWA, like there's ways in which the federal law requires this sort of fast tracking through the what's called permanency planning, right? You have to get quickly to adoption because of the idea that being in foster care for a long time is bad. There's a lot of rules about who can be licensed as foster homes. Historically, we didn't recognize living with your grandmother. So what we now call kinship care, that wasn't something that was recognized as an actual placement. So if you had a child living with a relative, they were often either taken as being someone who was neglected and not being cared for, or that was treated as some kind of temporary placement, and that kid had to be fast tracked to adoption. So there's a lot of stuff in federal law kind of outside of ICWA. ICWA doesn't apply to tribal courts, it applies to state courts. And so tribal courts are involved in doing this. And I do a lot of work on rating child welfare laws and amending them for tribes, and just the hurdles that come from other parts of federal law. Tribes often, when they are trying to infuse resources into their courts, I think one of the first places they want to do that is to work with kids. I see a lot of tribes who are trying really hard to do this work, and if they were set up to do it and funded to do it and had the foster homes and had the courts, then we wouldn't need, we'd see some kids in state court because they just lived outside of Indian country when it all started, but a lot of them would be able to sort of go to their tribes and have it litigated there. So that's sort of one underlying thing that's happening. The other thing is there's this private adoption industry that's quite profitable. And so just as an example, in the adoptive couple case, the tribe is a lot of the stuff happened outside of the state where it actually ends up going to court. It's not an accident that it went to court in South Carolina. There are some states that are known as being really easy adoption states, where the way that the laws about parenthood work make the children free of a family and available for adoption, and advocates for adoption know that, and they pick and choose among those courts. So there is a profitable private adoption industry that is also pushing to make, Bethany Berger has written some good history about this, but the way in which Native children in particular are seen as being kind of available and adoptable and more assimilable than other children, where we see, say, Black children languishing in foster care and not being adopted. So there's this other thing in the shadows here that makes ICWA especially important.
Thank you for that. So we have just 4 minutes left. So I think what I'm going to do, there is a question that I'd be interested in knowing the answer to. It says, in response to Burkine, there seems to be a concerted effort by tribes throughout the country to push their state legislatures to pass state ICWA laws. Are there any coordinated efforts on this front among tribes? And I don't know if anybody knows that, but what I would like to do is just go through and ask for each panelist to just give just 1 minute remarks, just to kind of wrap things up, your last thoughts. And let's start with Professor Reese.
Yeah, sure. So I think that especially a lot of this discussion has highlighted ways that we should remember how Native people and tribal entities that they are a part of are just a very different thing within the United States than the other minorities that a lot of people who even care very much about equality and justice and many of the things that ACS stands for are. That's, Indians are just different. We have a different status and a different situation, and also the stakes of things going on are very different. And I think that ICWA and the Brackeen case really illustrates this, beautifully, horribly, because, when I think about it, all of these tribal nations are trying to ensure that the process of having their children taken away through federal government policies that were intended to take those kids away as part of the forced assimilation and dissolution of tribal governments, exactly like Justice Marshall, anticipated, that doesn't happen. And so this is still about not just being treated fairly or equally within American society. This is about survival, whether or not these communities are going to, with any of their cultures and traditions, and any of that's going to exist, not just here, but anywhere. Because if it dies here, it will be gone. And so the stakes of this fight could not be higher. And so the contours of getting all of these complexities right, I really just, for those of you who are learning about this now, I encourage you to keep learning because it really, really matters.
Thank you, Professor Reese. Let me turn it over to Chase for your 1 minute closer here.
I would say that we swore an oath to uphold the United States Constitution. Now, for me, as a member of the Sioux Nation, my elders are like, "What is wrong with you?" But that is to protect the Constitution against all enemies, foreign and domestic. And the American Constitution Society, based on all the work that it has done in truth, reconciliation, in promoting that first step, which is a truth telling. We have to continue this very great work, because it's going to determine, just like at Standing Rock, who can call who a terrorist. Because I was called a terrorist there. Right now, there are people being called terrorists, being sentenced to 8 years in prison. Jessica Reznicek and Ruby Montoya is next to be sentenced for these terrorism enhancements. Because as a matter of national security, we're protecting private extractive profit margins. Those are all items that are challenging our constitutional acuity right now. So I look forward to all the work that everyone is doing who I didn't get to meet or see on the panel, and just thank you all for doing this today.
Professor Rolnick, your closing remarks.
That's hard. Thank you for letting me be part of this today. And just the questions have been really great and kind of overwhelming, and I feel like we didn't get to a lot of them. I do think I saw a lot of the questions about, Chase, I really appreciated what you said about the protesters, and I saw a lot of questions about that I feel like I feel bad that we didn't get to. But I do, just in the broader sense, I guess what I would say is think about, if you're thinking about the Constitution and how do we make this work correctly, if you compare sort of the Brackeen story, right? So you've got a situation in which tribes have been able to kind of somewhat successfully use the law to do a really important thing, which is to protect children. And then you've got this Goldwater think tank that just won't stop trying to take it apart until eventually, potentially, they start losing in court. And so even worse is kind of the story of what tribes tried to do to protect land that they didn't necessarily have jurisdiction over in the US system from drilling and from sort of all kinds of abuses. The legal system really doesn't work there. You can try all kinds of going to court remedies, but it's pretty hard to protect that land. So that maybe helps explain why it is that at the last second, people stand up in front of bulldozers. And if you have questions, sort of about the legality of what's happening or about why it is that people are doing things and how that's being used, I would just say, look at it all together. Look at the ways in which tribes have tried, I think, more than any other group to use the legal system, and the ways that sometimes fails. And then the ways that, the police are then used and that the kind of allegations of terrorism in the courts are then used against people who stand up when it's necessary to do that.
Thank you for that. And finally, Matthew, if you have some closing comments, and let me also add my apologies for not getting to all the questions. There were a lot of good ones, but Matthew, take it away.
I'll just come back to the mantra that the current assistant secretary would always used to say to us, and I probably told him to say this, which is, when Indians go to the Supreme Court and anywhere in the judiciary, all we ask is you uphold the law. Indian law is really simple. There's a few foundational principles. If you follow them, you apply some default interpretive rules like the canons of construction, over and done with. It's when you get those opinions that go on for, in this case, literally 325 pages, where it's all mischief. And they're desperate to find an avenue to get around in Indian law. And we'll have to see what this, how the court is, what the court is going to do with Brackeen. Everything will come down to the questions that the court agrees to hear on certiorari. If they are limited questions, limited to the issues that the Fifth Circuit was very concerned about, then we're probably in good shape. But if they agree to grant broad questions of congressional powers, broad questions of equal protection, commandeering, then all hands on deck. That is a terrible, terrible sign. I would add that there is an incredibly simple piece of legislation that could amend the Social Security Act to make ICWA foster care money that the federal government pays to states, to make it, make that money contingent on compliance with ICWA. It would make almost all of the serious constitutional questions go away. So if you're interested in helping your tribe or tribal communities look for a legislative option, keep in mind that will be hopefully coming down the pike in the next.
I just want to thank the distinguished panelists for this really interesting and robust conversation, and appreciate the audience here as well. Thank you for joining us today. Take care. Happy Constitution Day.